rise. First District Court of Appeals now in session. All who have business before this court, draw near. Give attention, you shall be heard. May God save these United States, the great state of Florida, and this honorable court.
Thank you. You may be seated. Okay, good afternoon. Welcome to the First District Court of Appeal. We have one case on the docket today. It is Sims versus State of Florida, 21-869. Mr. Offerman, you may proceed when you're ready.
May it please the court. Good afternoon. Michael Offerman on behalf of the appellant Darian Mathis Sims. I'd like to reserve 5 minutes of my time for rebuttal. The sole issue in this case concerns whether or not the state presented sufficient non-hearsay evidence to violate my client's probation. My client was on probation, and then in August of 2020, the state alleged that my client committed 2 new law violations, burglary and battery. Subsequently, there was a VOP hearing, and there was one witness that the state presented at the VOP hearing. That was Deputy Batchelor. And Deputy Batchelor said that he arrived at the scene after it had been reported to law enforcement. He came in contact with the alleged victim, Ms. Hearns, and he relayed what Ms. Hearns said to him. That Ms. Hearns said that my client allegedly had come into her apartment, broke in, that was the burglary, and then allegedly battered her in the process, that was the battery. Deputy Batchelor took photographs of Ms. Hearns' injuries. He also took photographs of the apartment that would have verified that there was some attempt to get inside. And at the conclusion of Deputy Batchelor's testimony, the state rested and argued that that was sufficient based on his testimony to establish that my client violated probation. Obviously, in my briefs, I've relied substantially on this court's opinion in Melton, and I've in particular relied upon the language where this court said that while hearsay is admissible at a probation revocation hearing, a revocation of probation may not be based solely upon hearsay evidence, and where the state seeks to revoke probation based on a violation of Standard Condition 5 by the commission of a new offense, it is required to present direct, non-hearsay evidence linking the defendant to the commission of the offense.
So, Mr. Offerman, let me ask you about that. So you're absolutely right. So the Melton decision relied on pre-Russell case law for that statement. But that case didn't turn on the lack of the nexus here. Didn't the court, the panel in that case, hold that there was absolutely no non-hearsay evidence supporting the offense?
Certainly, the VOP was affirmed in that case. So, yes. I mean, obviously, I would point out that Miller also cited to Melton and repeated that exact language just last year. I acknowledge there is confusion, I think, among Florida courts as to what is required after Russell. But I would say this, based on every case that I've reviewed, I'm not aware of a single case, including all of the cases cited by the state, where there hasn't, if you don't want to call it a direct link, at the very least been some corroborating evidence showing that the defendant was the one that committed the offense.
Why do you think that a violation based on a new offense should be treated differently than any other violation?
I think a lot of the other technical violations involve conditions that would be in the VOP or in the probation order. Those are things that the probation officer generally can testify to directly. But when it comes to the commission of a new offense, that's generally not something that a probation officer is going to know. It requires other evidence to show that the new offense was committed.
Well, but that's a question of how to establish it. But if it sounds like you're saying that even though hearsay and some non-hearsay can be used to establish some other violation of probation, when it comes to a VOP based on a new criminal offense, there has to be more than that. There has to be this direct link as well. And why would it be a different test for that type of violation? Let's say it's not a technical violation, it's some other violation that is not a criminal offense, but it's another, one of the other items on the very long list of conditions.
My limited understanding, and I'm no VOP expert, but I think everything falls into the category of, or I've always said, that it falls into the category of technical or new law violation. So I don't know that there is anything in between. Your Honor, I'm not sure I'm prepared to address that. I do want to address what is required for a new law violation, whether that's The same for a technical violation. I'm willing to acknowledge that for purposes of the argument today. At the end of the day, ultimately, there must be some non-hearsay evidence that in some way corroborates that it was the defendant who was involved. Even if you don't say link, even if you don't, and I acknowledge that Florida Supreme Court seemed to back off of saying that the non-hearsay evidence must independently establish that the defendant committed the new offense, but there must be at least evidence that corroborates it. And let me give you some examples. So from Russell itself, I've obviously argued this in the briefs, in Russell, the defendant came into contact with the law enforcement officers and he admitted to them that he roughed up the victim. That, of course, is non-hearsay. That's an admission by a defendant that would be admissible as an exception to the hearsay rule. I think that's an important point. Another point I want to make about the Russell case, and it's probably the most important thing that I'll say today from the Russell case for purposes of my client's argument. This is the first sentence from the second to last paragraph of the opinion. And it says, and I quote, "Thus, the trial court considered more than just the victim's hearsay statement and direct testimony of observation of victim injury." They go on to say what those other things were. One, it was Mr. Russell testified at that VOP hearing, so the judge was able to determine and make an evaluation of the defendant's credibility. And again, as I've already said, there was the testimony about the defendant making an admission. So I think the only reasonable way to read that sentence is if it was just those two things, that wouldn't be enough. In our case, it's just those two things.
But isn't that what the Supreme Court rejected, the holdings of the Second and the Fourth DCA in the Russell case on direct conflict, and ultimately said that, I mean, we disagree with the requirements that were established by the Second and the Fourth. Corroboration of every aspect should not be required in order to establish that the probationer committed a battery for the purpose of revoking probation.
But there must be a non-hearsay corroboration. I'll acknowledge, step back from Melton, doesn't have to be direct non-hearsay link that it was the defendant, but there must at least be corroboration. Let me give you another example. Again, the cases that the state cited, Thompson from the 3rd DCA, they go on and acknowledge that in that case the victim testified, that's hearsay, but then they say, this is the 3rd DCA, I'm quoting Headnote 7, here, hearsay evidence was admitted at Thompson's VOP hearing. This was not the only evidence, however. And they go on to say non-hearsay evidence was also introduced, revealing that Thompson fled the scene. Thompson tested positive for gunshot residue. A firearm was located near the spot where Thompson was apprehended. Other firearms were found in the passenger seat of the vehicle in question, and Mr. Thompson's flip-flop, he was barefoot, but one of his flip-flops was linked to the vehicle. In that case, the new law violation was shooting at a police officer and also possession of a firearm. That's any one of those by itself would be enough. He tested positive for gunshot residue. We know that there's I would say that's a direct link, but at the very least, that's corroboration that the defendant was the one involved in that case. The next case, again cited by the state in its answer brief, Nugent. They go on to say, in this case, that you had not only the deputy's recitation of what the alleged victim said, they had a recording of the alleged victim's statement about the offense, which the judge was then able to consider, and the court goes on to say could listen to the iterations in the voice and the assuredness of the victim. And beyond that, you actually have law enforcement coming into contact with the defendant in that case, and he acted aggressively. He actually threatened to shoot or kill one of the officers. So the idea there is when a defendant has nothing to hide, he's not going to act that way, but when they came into contact with him, he acted so aggressively and even threatened to shoot them. That would be corroboration that the defendant is involved in that case. There is no corroboration whatsoever in this case that my client was linked to either of these offenses. Now let me address the call. Because the state's
Well, I mean, there's corroboration, it's hearsay, but
I'm
there's
sorry.
hearsay that corroborates because he's saying what the victim said.
Thank you, Your Honor. There's no non-hearsay corroboration that my client was involved at all.
But you acknowledge that there also is non-hearsay evidence in this case.
Photos of injuries and photos of the break-in.
Right, so proof that there was a crime
But-
committed.
But another element, going back to the Florida Supreme Court's opinion in Russell, you don't have to corroborate each aspect of every element, but you have to show that it was the defendant that actually committed the new offenses.
Well, that's the Vidali case that you've talked about in your
Sure.
brief, which I find most similar to this case.
I agree. And again, a couple other things. I do want to address this phone call. So Ms. Hearns told Deputy Batchelor that during the evening, and even during the time that he was there, that my client was the one who was allegedly calling and texting. And this is all we have regarding that as far as the deputy's non-hearsay testimony in that regard. It's at the bottom of 427, top of 428. Question, and at some point, did Mr. Mathis Sims call her while you were present speaking with her? Answer, yes. He repeatedly called the entire time while I was conducting my investigation. At one point in time, I got on the phone and told him to quit calling, and he continued to call anyway. The non-hearsay of that is that someone called while he was there. The phone was passed to him. Apparently, there was a male voice on the other line. I guess you can assume that. And he told that person not to quit calling. There's nothing that establishes through non-hearsay that it was my client that was calling. The non-hearsay is just, again, what he observed. Now, there could have been a way through non-hearsay to show that it was my client. He could have said, and I'm familiar with the defendant's voice, and when I picked up the phone, I recognized the defendant's voice as being Mr. Mathis Sims.
Because it was a block number.
Right? Right. There's phones sometimes that the name pops up. He could have said, as I was talking to her, I looked at her phone and Mathis Sims popped up on the phone. And then that would be non-hearsay. He could have gotten a subpoena for phone records and said a cell phone linked to Mr. Mathis Sims' account called at the time that he was there. None of that occurred. Establishing that the phone call occurred, that's non-hearsay. Establishing who made the call, that's only hearsay. That's not non-hearsay.
What do you think that, do you agree that the origin of all of this, and you just trace it all the way back, cases cite cases that cite cases, if you go all the way back, isn't the origin of this, we want to call it a rule, requirement for due process that before a defendant is revoked, he has an opportunity for a hearing in front of the judge, and it should be, I guess, a fair hearing in some way.
No.
And if not, can you
don't.
identify the origin of this rule? Like, where is it a part of the Constitution? It's certainly not the rules of evidence.
I think the idea is there must be the greater weight of the evidence to show that the defendant is the one that committed the new law violation. And when we have that standard, and it's the state's burden, it's not as high as a jury trial beyond a reasonable doubt, but we know in a jury trial, hearsay is inadmissible unless it meets one of the exceptions. So we're not going to allow the state to meet its lower burden in a VOP proceeding based solely on hearsay. There must
And why not?
Because hearsay is not reliable.
Right, but
We've
Supreme
heard on the
Court-
news for the last 24 hours about how hearsay is not
Sure.
reliable and people being in limos, this, that, and the other. The exact same thing applies, obviously, in our Florida criminal justice system. We don't allow hearsay by itself to be the basis to find that someone violated probation and subject them to losing their life or liberty.
Sure, but a VOP hearing is also not a criminal trial, as you know.
It has a lesser standard.
Right, and probation is a matter of grace from the state and from the court in the first place. And it's the court's broad discretion, that's the Supreme Court speaking, broad discretion to determine whether a violation has happened and whether to revoke. So I don't understand where this idea that there has to be this strict adherence or some sort of this stricter corroboration requirement than what the Supreme Court itself said, which is just that there has to be some support from non-hearsay evidence. It doesn't go so far as to say corroboration.
The non-hearsay evidence that only shows that a crime was committed, but in no way, and again in this case, in no way even hints that it could be the defendant, simply is not sufficient. And again, the best example I can give you is every single case that has upheld a VOP in a situation, there's something in there that corroborates that the defendant was involved. The next case that I would cite to is, obviously I've cited Vidal, as Your Honor acknowledged. In Vidal, the Fourth DCA specifically said, I quote, "The state failed to present any non-hearsay evidence connecting appellant to the burglary." Even in the Reynolds case from this court, no, I'm sorry.
Well, in the cases where the revocation was upheld, you could distinguish some of those cases because the victim testified and said, my alleged perpetrator, he or she is right there.
Yes. And the case I wanted to cite to, Your Honor, was Rogers. And in Rogers, it's again from this court, 2015, it was an armed robbery. And in Rogers, again, the state was relying upon hearsay, the alleged victim's assertion about the armed robbery, but then the police officer got a bolo matching the description of the person that he pulled over, and the police officer said, in the vicinity of the person I pulled over that matched the description of the bolo, there was a weapon and jewelry that the victim later acknowledged was her victim and her jewelry in her purse. So again, there's lots of, even in every case I found, there's something that at least starts to point the finger that it could be the defendant involved. absent something that it somehow links the defendant, simply saying that we have non-hearsay that yes, there's injuries, and non-hearsay that yes, there's some type of break-in, but doesn't in any way show who the person that did that, other than her hearsay statement that it's the defendant, that's insufficient.
Can the trial court take into consideration the fact that the probationer refused to testify? And if so, or if it can't, why not?
The trial court didn't take that into consideration, I guess is my best
Well, I'm
answer.
saying, but could the trial court, implicitly, it doesn't say, the court doesn't say it on the record, but it is a fact that your client had an opportunity to testify and refused after consultation with counsel.
Again, I don't know that I'm prepared to answer that, Your Honor. I promise you that if the trial court had said, one of the factors I'm considering is that the defendant refused to testify, I would have fully briefed whether or not that's something that would be a proper consideration. The trial court in no way, in the very short analysis that was given by the trial court, said one of the factors that I've considered in deciding that there's a greater weight of the evidence to violate probation is the fact that Mr. Mathis Sims was here and chose not to testify. That's not at all what is relied upon, and the judge did give factors that were relied upon.
Right, but the judge ultimately it has the broad discretion to decide whether to revoke.
As long as sufficient evidence is presented.
Well, and you know what the court is observing in court as well, and what's going on, and why. I guess I'm still coming back to this idea that if the point of a VOP hearing is just to afford a probationer due process, an opportunity to address these assertions that he's violated his probation. And, you know, he can do it in a variety of ways. He could cross-examine the witness, for instance, or through counsel, or he could testify. And he's given the opportunity, he doesn't take advantage of any of that. Why doesn't,
Your Honor, again,
why doesn't that by itself comport with due process and sufficient that where a trial court does have evidence in front of it, to support a violation, that why isn't that enough under all the circumstances?
Your Honor, I apologize. I'm not prepared to argue whether or not the standard should be less than what was set in Russell. I've conceded earlier that Melton seems to go further than what Russell requires, but at the end of the day, I've said that Russell still requires non-hearsay and some type of corroboration. If you're asking should it be less than that, my argument is no, it shouldn't be less than that. If you want me to justify that, I'd be happy to submit a supplemental brief discussing can a court consider whether or not a defendant did or did not testify. Again, it's not a factor that's considered in this case. And I can discuss what's the basis of even allowing having a VOP hearing and why does it have to be some non-hearsay. I'm just not prepared to argue that right now. That's not something that's been argued by the state. It's certainly not something that I've researched. Let me go back to, in this case, I'm running into my rebuttal time. There are things that the state could have put on in this case. Most notably, the deputy bachelor says, when I was talking to Ms. Hearns, she said that the perpetrator ran into a blue car and she took a picture of that blue car and the license plate. She actually showed that picture to the deputy. In all the transcripts I've read over the years, the next thing you'd be expecting to come out during that hearing is, oh, and then we ran that plate, and that plate was linked to the defendant in the case. Nothing. They had the license plate number. They could have put on some non-hearsay evidence to show that that belonged to my client, and I would concede to you right now that would meet their burden. Nothing. The neighbor. Again, I understand why the alleged victim didn't testify at the VOP hearing. She recanted. We know that. That wasn't presented at the VOP hearing. It came out at the sentencing hearing. But the neighbor, Deputy Batchelor said, I actually went and talked to the neighbor who said, yes, I heard a female screaming. Yes, I heard banging. And the neighbor actually said that I saw a black male run and get into a blue car. Why not put the neighbor on? The neighbor can say, look, repeat exactly that. Deputy Batchelor is correct. And by the way, the person I saw running towards that blue car matches the description of that guy sitting in the courtroom over there. They didn't put on anything else. The burglary case, fingerprints. I don't know if fingerprints were left or not, but easily they could have tried to see if some fingerprints were left at the scene and then put on some evidence that those fingerprints matched. They had many different avenues to put on non-hearsay evidence that somehow would have linked to my client, but the way this record stands, there is no non-hearsay evidence in any way linking my client. Everything that has to do with the name Mathis Sims is hearsay from the alleged victim's mouth. And that's simply, under our current law, maybe it should be different. You may be advocating for that, Your Honor. But under our current law, the non-hearsay evidence presented in this case was insufficient. And I'd ask this court to reverse. I see I have almost 2 minutes left. I'll reserve my time. Thank you.
Thank you.
Please, the court. Good afternoon. I'm Darcy Townsend for the state of Florida. Mr. Efferman wants to use Melton to carve out an exception that direct non-hearsay evidence needs to link the defendant to the commission of the new crime, and create an exception to Russell, but the Russell holding is clear. The decisions thus demonstrate that the 2nd and 4th District require that non-hearsay evidence independently establish the probationer committed the battery. We disagree with such a requirement. And it goes on to say corroboration of every aspect should not be required to establish that the probationer committed a battery for the purpose of revoking probation. The Russell Court does not qualify that every element except identity should be shown by hearsay evidence. It merely requires that non-hearsay evidence must support the hearsay evidence. In this case, the victim names the appellant by name, tells the deputy that he broke into my house, he dragged me down the stairs by my hair. The photos corroborate that. You can see the chunk of her hair missing, her eyelash on the stairs, and her weave on the stairs.
Counsel, can we so on that point, do you believe, or what do you think about Deputy Batchelor's testimony at the hearing? Was it evidence?
Yes. And the trial court weighed that evidence. The other evidence that was presented, the photos, the testimony of his personal observations, and found that credible. This court can't reweigh the credibility. The appellate court's job, as the Supreme Court said in Timms, is to merely evaluate whether the evidence is present to meet every element.
Because it sounds like from Mr. Ufferman's argument, I think it was a suggestion that hearsay alone would be, or a lot of hearsay would be problematic because it wouldn't meet the preponderance of the evidence standard. I thought he heard, and he can, if I misheard it, I'm sure he will correct me on rebuttal. But let's talk about the nature of evidence. And if the probation court or the trial court is in determining whether a violation has occurred, here's evidence, here's testimony. Someone takes a stand and they testify as to what someone told them as to what happened. It sounds like that would still be evidence, even if it, like the rules of evidence or the definition of hearsay, and sometimes hearsay is excluded. Do you think that that otherwise means it's not evidence, or it's just excludable evidence?
It is evidence in a violation of probation case. The Russell court says that how much is needed, that is for the trial court to decide. The appellate court just reviews whether or not it's present. Not, the appellate court doesn't quantify how much is needed. That's the province of the trial court.
So what do you think the purpose is of this, the requirement that there be in some form non-hearsay evidence?
As far as my research tells me, it evolved from a harmless error argument from conditional release cases in the 1940s to evaluate whether or not the defendant had, evaluate whether or not he was on good behavior, and had satisfied the conditions of his release or the conditions of his probation. It evolved from hearsay being not being reversible error to the rule that hearsay is admissible in a revocation proceeding as long as there's something else to support it, to kind of get to that preponderance of evidence standard where you're relying on verified facts. And in this case, there are corroborating
Well, doesn't
facts.
Melton, if we agree with our court's interpretation of Russell, in Melton we said there has to be more than non-hearsay if the revocation is based on a new law or new charge, a commission of a new criminal act. And so in this circumstance where we have that allegation, how do you get around Melton saying you've got to have some non-hearsay evidence to put the perpetrator at the scene, to put the defendant at the scene? What do we have here specifically that puts him at the scene that is non-hearsay?
The rule in Melton, which does not cite Russell, is incorrect. You don't have to have direct non-hearsay evidence linking the defendant to the commission of the crime. That would place a higher burden at a VOP hearing. On the state, then you'd even have in a criminal trial, because the identity can be proved circumstantially.
Well, and as I asked Mr. Upperman, I do think Melton cited I don't think that it did. It cited pre-Russell case law for that statement. But address Mr. Upperman's point that in Russell, and then based on his research, every case that has followed Russell, there was some non-hearsay corroboration placing the defendant at the scene of the crime or involved in the crime.
That is a fact in Russell, but that's not what the Russell decision turned on. And it goes back to, in this case, the trial court evaluates the evidence that is presented in the totality of the circumstances, and found that the defendant had committed the new crime. There was the evidence of the victim named him by name. She took a picture of his license plate. This was a personal relationship. It was somebody she knew, and the appellant was pulled over later by another officer. There is sufficient evidence that identifies him as the person. It doesn't need to corroborate every aspect of his identity.
Do you think that the omission of the photos, is that basically that's what turned an otherwise loser case on appeal for the state into a more arguable case? Like, let's take away the photos. If it was just Deputy Batchelor and there was no exhibits admitted and it was just his testimony, would that be a bad case for you?
You still have his observation, his testimony, and the court can weigh the credibility of that.
Observation of what specifically?
Of her injuries. He says the door was clearly kicked in, the lock was across the room, which corroborates what she said about him breaking into the house, and his testimony about her injuries, the hair still on the stairs, her eyelash still on the stairs. His observations corroborate what she told him.
But what non-hearsay evidence do we have that it was him, that it was Mr. Sims? Mr. Efferman made I think an interesting point about the phone call. Even though the officer looked at the phone, it says it was a blocked number. There was no testimony elicited from the officer that said that was Mr. Sims. He identified himself, or I saw his name on the phone.
It doesn't need to be non-hearsay evidence to testify or to corroborate that it's him. The victim says, he's been calling me and texting me all night. This is him. The officer spoke with him too. It corroborates her statements to the officer that he's still calling her when she's on scene. It doesn't have to be non-hearsay evidence.
Well, and if we look at the way the issue was teed up before the Supreme Court in Russell, it was whether the trial court erred in sustaining the revocation of probation based only upon the hearsay statements of the victim and the observation of an injury to the victim. So it doesn't get into this other requirement that there also must be non-hearsay evidence placing the appellant or linking the appellant to the crime. I mean, that's how I read how the issue was teed up in Russell and decided in Russell.
Correct. The way I read that is that the officer's testimony and of her hearsay statements would be enough to revoke, for the trial court to weigh if the trial court finds that evidence credible, and it's enough to sustain a revocation.
But of course, as Mr. Upperman notes, I mean, the court does go on and say that the trial court considered more than just the victim's hearsay statement and direct testimony of the observation of the victim injury. So I guess my question is, have you uncovered any case post-Russell where there was no non-hearsay evidence linking the appellant, the defendant, to the crime?
To my knowledge, I can't think of one, but the rule in Russell is clear. Subsequently, the district courts have kind of attached on to that linking language, but it's not required under the rule of Russell.
Counsel, can you speak a little bit to the preservation argument? How specific do you think the counsel must be to preserve, I guess, an objection or an issue like this?
As I cited the Reynolds case, where they had, similar to this case, argued that there was not, the appellant had argued had attacked or had asked for in the Reynolds case, they argued that their evidence was insufficient because, based on the confrontation clause, as the appellant argued in this case, and found that that was not sufficient to preserve this issue. He did need to make a more specific objection to alert the court to make a ruling on whether or not the identity needed to be established. And the Reynolds case also found that they had not preserved the issue.
So is your argument is because the defendant's counsel at the VOP hearing asserted, well, my client has a right to confront witnesses testifying against him, almost like basically like a Crawford-type challenge, which is not the law, of course, that was enough to forfeit or not preserve the argument that they're making on appeal?
Correct, that he didn't sufficiently raise this specific issue.
Which specifically, you should have said, Your Honor, in addition to my client not being able to confront witnesses, this deputy's testimony alone doesn't meet the preponderance of the evidence standard, or there's not enough
To identify
direct
him.
evidence or non-hearsay evidence or something like that?
That
Is
would have
the
given
point?
the opportunity. I apologize.
No, it's okay.
It would have given the court an opportunity to address it at the time versus.
But didn't the trial court
arguing.
actually address it, though, in sort of the explanation that the court was explaining why it was going to revoke?
But they didn't contest that. There was no contesting that it was him. They did that after the fact. If they were going to contest that it was actually him on the phone, that it was actually
the
his
linking
ex-girlfriend,
part.
he needed to contest that or raise that argument in the trial court below, not up here.
Do you think, can a defendant / probationer forfeit or waive an argument like he's making on appeal by inaction at the VOP hearing? So I think there was one question asked on cross of the deputy. And it was basically, did you ever have any interaction with the defendant? Something like that. Can that constitute a waiver? There's many other questions that perhaps counsel could have asked the deputy. Presumably they didn't want to because, for I think obvious reasons, but could that be a waiver or a forfeiture of the argument?
Yes, he didn't. Asking that one question wasn't sufficient to preserve the same argument that he's asking on appeal, or that he's arguing on appeal.
All right, well, I'm asking a slightly different question. Not in an argument sense, but if VOP, again, is not a trial, this is for the trial court to exercise its discretion as to whether to revoke, and has broad discretion. Probation's grace. You don't have a right to probation. You don't have a right to keep probation. The trial court is viewing this hearing, the defendant's lack of really participation in fighting the assertion that there is a violation, either through testifying or more vigorous cross-examination, something like that. In the face, the state has brought forth a witness and it's testified, presented some evidence indicating that there's been a violation. Does the defendant bear any responsibility to fight that back and maybe present evidence or contest it through cross? And before you answer, I also ask, is there any support for that position in the law? And that's okay if you're not prepared to address it. It's fine too. Mr. Ufferman's already played that card, and it's okay if you play it as well.
Not to my knowledge, and I think what gets hairy is that he has a Fifth Amendment right to, even if that this is a violation of probation hearing, and a determination of guilt has already been made in the case he's before the court on, that the battery was still pending.
Yeah, but he didn't assert his Fifth Amendment right. That's not why, he didn't say that's why he wasn't testifying. He just chose to not testify. They asked, he consulted with counsel, came back, and said, no, thank you.
I'm not prepared to brief that, but I can research and have a response, Your Honor.
And the reason I'm asking overall is, again, so if we're going to say on the one hand that this is not a trial, then on the other, why would we then address arguments as if it is still a trial and engage in this in evidentiary discussions? And, well, he didn't testify because he didn't have to because he had a Fifth Amendment right. Well, but it's not a trial. And the same with hearsay versus non-hearsay. Why are we exercising or trying to apply this more strict standard in what is the ultimate in judicial discretion, which is, whether to revoke someone? That's the source of my question. And,
Well,
I don't have anything else to say on that.
Okay. Well, there is corroborating evidence, so it's not just resting on hearsay. There is non-hearsay evidence that corroborates what the victim told the officer in this case.
So you would draw so if there's any non-hearsay evidence that suggests that this thing happened, it doesn't matter what element or what part of the offense or the event it goes to prove, as long as there's something and not just Deputy Batchelor testifying for 30 minutes saying this is what the victim told me.
There has to be evidence in the record to support, but it doesn't have to be, there has to be evidence to support each element, but it doesn't have to be hearsay versus non-hearsay for each element. As the Russell Court says, the non-hearsay must support the hearsay evidence, but it doesn't have to corroborate it in every single aspect.
So would you say that the only way that an appellate court could avoid weighing or reweighing the evidence or reweighing what the trial court did is to look at it more from a burden of production? So the state has a burden to produce some non-hearsay evidence to establish the circumstances of this event that constitute a violation. And it doesn't matter what that evidence goes to show, but it certainly doesn't have to be the nexus part, putting the defendant at the scene. Just has to be something to support the hearsay.
Yes, it's similar to a JOA argument, just like the court says in Tibbs, reviewing whether or not it's present, not having to weigh the evidence. If there are no additional questions, the state respectfully requests this court affirm for the reasons here and in the state's answer brief. Thank you.
Thank you.
May it please the court, I'm hoping to make 2 quick points. The first one's regarding preservation. I think the law in Florida, in case law, establishes that as long a challenge to the sufficiency of the evidence is preserved so long as it is, a sufficiency of the state's non-hearsay evidence is preserved so long as it is raised below. Clearly, as I quoted in my reply brief, the defense attorney did argue that their hearsay is all that's supporting the state's allegation. There's not non-hearsay to support it, and therefore the court should not find that there was a VOP. I think in the Reynolds case, the court went on to say that what was argued by the defense attorney in that case at the VOP hearing was that no offense occurred at all, not that there was a distinction between hearsay and non-hearsay. The final point I want to make, and it's what I said earlier, that I think the most important sentence for purposes of my client's position is that sentence that I quoted from Russell. The Supreme Court said that the trial court considered more than just the victim's hearsay statement and direct testimony of observation of victim injury. That's all we have here. The Supreme Court went out of its way to say that that was not all that they had there. There was more. My research, and there may be something out there, but I can tell the court that based on my research, there's not a single case that has upheld a VOP in this situation without some non-hearsay evidence that somehow corroborates that the defendant was involved. It may not be that he was directly at the scene, may not be that he actually committed the offense, but it could be that he has gunshot residue. Would gunshot residue alone stand up at a trial? Probably not. But is that enough to show that, that's pretty coincidental that he has gunshot residue and the underlying offense is that someone fired a gun? We don't have that here. And of course in Vidal, that was post-Russell, they cited Russell, and the 4th DCA made the same argument that I'm making in this case. So I'd ask this court to reverse. Thank you.
Thank you. Thank you, Mr. Upperman. Thank you, Ms. Townsend, for your presentations today. The court is adjourned.
All rise.